Hello everyone, welcome to Crystal Diaries. This is another video of the series of videos relating law of contracts in India. And as you have already seen that today we are going to discuss about consideration, which is a very important concept in contract. I have made two separate videos for this. The first one being this and the next video. In this video, we are going to discuss about what is consideration, what are the important elements of consideration, and in the next video, we are going to discuss about the exceptions of the general rule of consideration with some illustrations and case laws. So let us begin, but before that, you have to bring your Bare Act, a notebook and a pen so that we can read the Bare Act simultaneously and note down any important points, whatever that will be discussed here. So let us begin. So, what is consideration? If I say in layman's language, it is the price of the promise. Like if I promise you to do something, then you must give me something in return. So that is consideration. And if you promise to do something for me and I give you certain things, then that certain thing is consideration. Okay, so let us first know what is consideration in the context of Indian Contract Act. So where is consideration defined? It is defined under section 2D of the Indian Contract Act. It says, when at the desire of the promiser, the promisee or any other person has done or abstained from doing or does or abstains from doing or promises to do or to abstain from doing something, such act or abstinence or promise is called a consideration for the promise. So let us analyze all this one by one. See, first it writes when at the desire of the promiser. So whose desire is important here? The promiser. Like the promiser must have said that I desire this. Next part is the promisee or any other person has done or abstained from doing. So the consideration must be from the promisee, or that act or abstinence must be from the promisee or any other person. And it tells about three different things, like has done or abstained from doing, means it is talking about the past tense, like you have done or abstained from doing something. Again, it is talking about the present tense where it says does or abstains from doing. Again, it's talking about the future time where it says you have promised to do something or to abstain from doing something is called consideration for the promise. Okay, now let us understand this with the help of an example. A gives a book for a price of ₹100. Like most of us think, what is the consideration here? Obviously, ₹100. But no, that is half of an answer. Consideration works both ways. Here, A's consideration is ₹100. Okay, and B's consideration is the book, because A gives a book to B for what? He gets 100 rupees. Now what does B get by giving ₹100? It gets the book. So consideration works both ways. So a very general principle is this, that if there is no consideration, there is no contract. But since this is law, there are exceptions. So this is the general principle and there are exceptions to this, which we are going to discover in the next video. So now let us move to the elements of consideration. We are going to discuss them one by one. So the first element is the consideration must move at the desire of the promiser. So it means that the promiser must desire for something and that must be done, or which has to be done in accordance with the desire of the promiser. So if such consideration is made at the will of a third party or without the desire of the promiser, it will not be a good consideration. Okay, now take an example. There are two persons, A and B, and A saves B's goods from fire without being asked to do so. Can A demand the payment for his service? No, he cannot, because B had not told it. Like, it is not at the desire of the promiser. So this is an important element. Now moving to the next element, the consideration may move from the promisee or any other person. Now what does this mean? This means that as long as there is a consideration, it is really immaterial who has given it. Now this is an important difference because in English law, the consideration must move from the promisee only. But under Indian law, consideration may move from the promisee or even a third party or a stranger. But the stranger to the consideration cannot sue until he is a party to the contract. Now, the very important case law is Chinnaya versus Ramaya. So, what happened here? The mother gifted or transferred the property to her daughter with a direction that the daughter should pay maintenance to the mother's brother or the maternal uncle. So the daughter executed the writing in favor of the brother, and what happened then? She refused to fulfill her promise, saying that there is no consideration that had moved from the uncle. But the court held that the uncle was entitled to maintain the suit. It is because the mother has actually given a direction here, the third party has given, right? So now moving to the third element. The third element is that the consideration may be an act, abstinence, or forbearance, or a return promise. Now this is simple. Now moving to the fourth one. The consideration may be past, present, or future. Like we have read in the very section. Now we are going to read it again here. Like the consideration may be past consideration. What is past consideration? That you have done or abstained from doing certain thing before the date of promise. Okay. Now the next is present or executed consideration. Like this is a very simultaneous thing, that on the date of promise you are giving something to the other person and the other person is fulfilling his promise. Now the third one is future or executory consideration, which means that subsequent to the day of contract you are going to give the consideration. First the promise will be fulfilled and then the consideration will be given. So consideration can be of three types: past, present, and future. Now moving forward, the fifth one is it may or may not be adequate. Like we need consideration, like it must be something, but it need not be adequate. It must be of some value. Now the next one is it should not be illusory but real. Like if you say that you are going to do an impossible task in exchange for another promise, now that does not amount to consideration. Let me give you an example, that if you tell that okay, you give me 100 rupees and I am going to pull out the stars from the sky. Well, is this a consideration? No, because it is not real, because it is impossible. Next, that the consideration should not be something where one is bound to do so. Like if someone is bound to do so, you cannot say that is the consideration. Now the best example is police. Okay, if a police says that you give me 100 rupees, you give me 1000 rupees, and then only I will catch the thief. Well, is this consideration? No, because he is bound to do so. He is being paid for that, right? So he cannot ask money from you. It is his duty. And the last part is the consideration must not be illegal, immoral, or against public policy. So if someone says that you give me 10,000 rupees and I will murder the other person, or I will wage a war there. Well, is this a consideration? No, because all these things are punishable by law. It is illegal, immoral, and are not related to public policy. It is very much opposed to public policy. So in these cases, the consideration is not justified, and subsequently the contract is also not justified. So I think we are clear with the elements of consideration, and then we should come to know that what are the exceptions to the general rule of no contract equals no consideration. But for that video, you need to check the next video in the playlist. So till then, keep on revising and take care. Goodbye.